Hey everyone, Rob here. Greetings, Clark County-lings. I just wanted to give you an update for Reform Clark County, my efforts here. As many of you know, I have an election complaint that I filed. There's Penny, by the way. She's just doing a little guard dog protection, make sure no one comes up on my six. Just want to give you an update here on the hearing today that was for a request for discovery. So it wasn't the hearing on for the complaint itself, but it was more of a request for discovery. Obviously, the more that we can kind of dig in and get some information, I believe that will kind of show the corruption, just show the complete disregard for the law and how they were just putting all of their efforts, the state, the Secretary of State, into just dismiss. Like it's just so obvious that was, they're supposed to be. They are charged with election integrity, making and protecting the election integrity, but it's very clear that they value really protecting election, but it's not integrity, protecting the way that they're doing it now. So, anyways, I had a hearing today on the motion for discovery. And it was interesting. I've done public testimonies, comments, things like that, but I've never, done something like this. So it was kind of a new experience for me in trying to kind of figure out. I prepared quite a rebuttal, but it really didn't kind of come down to that. The state got to make their claim, which their major claim is that I did not provide enough argument or make any argument for and of course they're gonna say things like this. They're not just gonna roll over, but they say that I didn't provide an argument justifying expanding the record. So it's pretty funny. So this is the record of the agency record, in which the judge can only look at these things. So it's kind of how bureaucracy really puts the advantage in their court. So they say, you can only use these things in your cases, which is kind of super limiting. And of course, again, it's rigging the rules kind of to help their advantage. And it's very bare bones. It's basically just the core documents. So the dismissal letter, my complaint, actually both versions of my complaint, the properly scanned and the improperly scanned versions, and that's pretty much it. But anyway, so they're saying that I didn't meet the qualifications to expand this record, which is RCW 3405-562 section 1, which is really odd because I argued, in fact, this is my prepared statement. I said, however, I maintain that my request for discovery falls within the scope of 3405-562 section 1. So I'm basically using their argument, flipping it on its head, specifically subsections B and C, as it seeks relevant information related to the potential errors in the decision-making process. So subsection B says you can't, so it only gives like 3 issues that you could expand this record, put more things in this envelope, so to speak. And one of them, subsection B, is that if there were potential errors in the decision-making process. Well, there was 100%. There was errors. So just on itself, using just alone the record itself, I should qualify for discovery. So I made that argument. And because these documents are relevant to show whether the defendant acted. So the defendant is Randy Bullerjack, the Deputy Secretary of State. Defendant acted arbitrarily, capriciously, or contrary to the law in denying my request, whether there are any factual disputes that require further adjudication. I went on to say, this is where I threw a shot over the bow. So you have to file motions and turn everything ahead of time and kind of go back and forth. Well, I didn't emphasize this next point kind of intentionally to hopefully catch them off guard, because there's a little bit of that in law lawfare. So this is what I said next. Notably, Mr. Bullerjack's false claim in his response, asserting that I failed to include my phone number or have the complaint notarized on a state-provided form, and I had those for the judge. She didn't take them, but I mean, they're part of the record. So she already had them. Demonstrates an unfair and inaccurate handling of the complaint from the beginning. Such misconduct raises concerns about the thoroughness and credibility of the state's response, further underscoring the need for discovering to obtain essential information, ensure a fair and just resolution. I mean, it just, to me, it's really obvious that this needs to be expanded. It needs to be looked into. She asked me a few questions. I mean, she was, she took the time to ask me questions and it was pretty respectful. But in the end, she denied my motion for discovery. It doesn't really, and it's kind of a good bad thing where I wanted discovery. Obviously, if you know me, I want more daylight on what the state is doing, and if there's corruption, it needs to come out. If there's misconduct, if there's whatever it is, we need to have that kind of information as the public. But what she kind of said was like, hey, all of that's already in the record, so there's no real need to have discovery, which is, I mean, partially true. That, yeah, my case is pretty solid. Just everything that's just right there that's undisputed is enough to kind of move forward. But I wanted more. I think it was a bit of a long shot anyways, and I thought I poked holes in their case. But the lawfare in the legal system, I mean, think about it. A judge who is wanting to maybe further their career probably knows that pissing off the state isn't the best way to do it, right? I'm not saying that she's being partial or whatever, but I think it's a subconscious kind of thing that drives everyone, right? But anyways, so I'm not discouraged at all. Kind of expected this. You have to thread that needle, they make it so difficult where all the rules, all the bureaucracy, everything's stacked in their favor. So I get it. But we did set a date for in August for the hearing, for the big hearing. So this would be the hearing itself on the petition of review. And the state has to give their response relatively, I think sometime mid-July, something like that. And I wrote it down, the dates, and then I get a chance to respond, and this is all in writing, kind of going back and forth. So yeah, that's what we'll be doing, and just wanted to give you a quick update. I'm not discouraged at all. In fact, I think I was able to kind of set the table a little bit on the strength of our case, and it was interesting that the Assistant Attorney General who's representing the state here, she did not really address that. Like when I brought that up, I think that the whole issue of improperly stating, because my argument was this record is not complete. Also, it doesn't address at all the mistakes that were made. So therefore, it's really lacking, and discovery needs to happen in order to complete and have a fuller picture. But anyways, the assistant AG, I mean, I could be reading wrong maybe, but it seemed like she was a little caught flat-footed on that whole issue and really avoided it. Did not address that at all, and the judge kind of like, "What's your reply?" And she just kind of stuck to what they had said before, and that was it. They didn't really want to address that. So it'll be kind of interesting to see. Again, I'm going to have to thread the needle. I'm very aware that, this is a David and Goliath kind of situation. Not that I'm a hero, but as in more of the odds are, against me. And, but we're going to take that. I totally believe in moving forward. And even in when the things haven't gone kind of my way, it still reveals. It's still kind of a learning process, and you still kind of get a better picture of what you're up against, and so that you can make adjustments and kind of understand what's going on. So I'm glad that I did this. It gave me kind of a perspective of what to prepare for in the hearing. And anyway, so that's it. I appreciate you, love you, and we'll continue to kind of move forward and keep fighting the fight. Take care. If you want more information, go to www.reformclarkcounty.com. That way you can stay connected to all that's happening.